Let's say that you are an unsecured creditor. How can you collect on that debt that are owed? If there is no security interest involved, how do you collect on the money that the borrower, that the debtor owes to you? Well, the process for collecting an unsecured debt often begins with the plaintiff creditor filing a complaint to start the judicial process. So again, obtaining a judgment is just the first step. If you obtain a judgment from a lawsuit, you must then go back to the court and ask the court to execute what's called a writ. And the writ will give to the judgment creditor a right to assert its debt against the underlying borrower. Oftentimes you hear this phrase judgment proof. A judgment proof defendant is one without any assets, or one whose assets are statutorily outside the reach of the creditor. States like Texas and Florida, which were created in large part by individuals who were seeking to avoid repaying loans, they provide a very broad protection for debtors. Most prominently in Texas, your homestead, the place where you live, is not available to be seized and sold to pay a debt. So if you are a person who's lost a lawsuit in Texas, one of the first things you'll want to do is to pay off your mortgage. Why? Because now you own the house and no one can take your homestead from you. Now, most states have some statutory limit as to how much is protected. Again, Texas allows you to protect the entire amount of the homestead. So those assets are statutorily outside the reach of the creditor. And again, this is a problem when trying to collect on a debt, is that many defendants can simply avoid repayment of the debt because they are judgment proof. One of the tools that a judgment creditor has is called garnishment. Once a creditor has obtained a judgment against a debtor, it is entitled to enforce the judgment. And one of the ways it can do that is through this process called garnishment. I go to the court seeking an order of garnishment against a debtor, and that order will direct a third party to pay the judgment creditor rather than the debtor. Now, generally you hear about garnishment of wages. Some states, most states, allow garnishment of wages. That means that if someone owes you a debt, you can then go to that person's employer once you've obtained your order of garnishment and tell to that employer, you must pay me and not pay the debtor, employee. Now, generally states limit the amount of garnishment. No state allows the garnishment of all wages, but some states do allow a large percentage of wages to be garnished. Again, I bring up Texas as an example of a state friendly to debtors. Texas does not allow garnishment of wages other than for the collection of child support. So most states allow garnishment. Texas doesn't. If you are a judgment debtor, best that you move to Texas or to Florida to protect yourself. Levy is a court order that authorizes the sheriff to take possession of the debtor's personal property on behalf of the judgment creditor in order to preserve the property from being transferred or sold by the debtor. Sometimes you as a creditor believe that the debtor has property and you are concerned about that debtor selling that property and taking the money and hiding it away rather than paying you the creditor. So we can assert a levy, and what that is a restriction. So for instance, on real estate, the sheriff, or in some states the actual judgment creditor, can file a notice with the county clerk's office to say this property is subject to a pre-existing lien. So levy can prevent the debtor from selling the property without payment to the creditor. Now, when we're talking about protection of the homestead, this is where we see it come in. Many states exempt real estate up to a certain dollar value if that real estate is used by the debtor as a primary residence, what we call a homestead. Discovery. To collect on a judgment creditor is entitled to conduct discovery. Discovery is a process in the law by which we obtain information from the other party. So if we have a lawsuit designed to collect on a judgment, I am entitled to ask that debtor, what properties do you have? And ordinarily this is done in the course of a deposition. You sit down with the debtor is in front of a notary, the debtor must swear an oath, and the judgment creditor or their attorney is free to ask questions of that debtor in an attempt to locate assets, whatever assets the debtor owns and where those assets located. Discovery can be valuable. However, oftentimes you have a situation where the debtor simply lies to you or refuses to tell you the answer. So don't over-rely on this discovery process. Once property has been levied against, the sheriff can sell that levied property. If you ever wondered what is the sheriff's main role, a sheriff does things beyond simply law enforcement, and one of those primary roles is to seize and sell levied property. And they will do it at auction. On the first Tuesday of every month, you can go down to the courthouse and there will be multiple creditors who have taken a levy against real estate and they're selling it off. If the auction doesn't produce enough revenue to pay off the debt, the creditor can continue to search for assets and they can levy any property as it becomes known to the judgment creditor. If the auction somehow produces more money than is required to pay the judgment, which realistically doesn't happen much, the surplus would then go to the debtor. But ordinarily, there's a deficit. The auction does not bring in the amount necessary to satisfy the judgment. State exemption laws, I've kind of referred to this already. Some states have exemptions on restrictions on garnishment and levy that places those certain assets outside of the reach of an unsecured judgment creditor, meaning if you don't have a security interest in that property, you can't take it. So, for instance, a debtor defaults and they fail to pay their car loan. Well, ordinarily, that vehicle is going to be protected. The creditor is going to be protected because it's taking a security interest in that vehicle. Those unsecured creditors, however, lose out on the ability against that vehicle because, for instance, in Texas, you have the right to exempt 2 vehicles. So again, a little bit of free advice. If you ever lose a lawsuit in Texas, go pay cash for the most expensive vehicle you can find, and that's going to be exempt from judgment creditors. We mentioned the homestead. This is the most common full exemption. There are also partial exemptions up to a certain dollar value for items such as cars or furniture or clothing, and for designated retirement funds. Those are all protected. So, for instance, you may have heard of O.J. Simpson. O.J. Simpson famously lost a civil proceeding brought by the parents of the murdered woman, his murdered former wife. And one of the assets that O.J. Simpson had was his NFL pension. That NFL pension was exempt. He lost his Heisman Trophy. That was non-exempt. But he got to keep his pension, which was arguably much, much more valuable. So in conclusion, what did we learn? A creditor can seek out multiple ways to guarantee repayment of a loan. A lien is an interest in property, oftentimes created through obtaining a judgment or through a state statute. And there are legal means to collect unsecured debts. That's all for this one. If you have any questions, feel free to let me know. Otherwise, we'll see you next time.